Welcome to the County of Santa Cruz Human Services Department Privacy, Confidentiality, and Conflict of Interest e-learning. As professionals in social services or related fields, we are required to practice the highest level of integrity in maintaining clients' privacy and confidentiality, and to avoid conflict of interest situations. The purpose of this course is to give you the tools you need to protect an individual's privacy, maintain confidentiality, and to avoid conflicts of interest. This course will establish and reinforce 3 important points. First, client privacy and client confidentiality is a top priority within the County of Santa Cruz Human Services Department, also called HSD. Second, we must comply with state and federal regulations. And third, we want workers to be aware that improper use of personally identifiable information may lead to discipline, including termination of employment. This policy, both directly and indirectly, impacts all employees, contractors, consultants, temporary or extra help employees, volunteers, co-workers, and any other worker at the County of Santa Cruz HSD facilities, including those workers affiliated with other county departments and third parties who access HSD restricted areas or HSD computer networks. This policy applies to all data, computer, and data communication systems owned by or administered by HSD. To best protect our clients' privacy and confidentiality, it's important to understand what is meant by personally identifiable information, or widely known as PII. PII is any information that can be used alone or in conjunction with any other information to identify an individual. PII is any information that can be used to search for or identify individuals, or can be used to access their files, and this includes accessing your own files without a business need to do so. Examples of PII include name, social security number, social security benefit data, date of birth, official state or government-issued driver's license, or even an identification number. Data provided by the Social Security Administration may also contain PII. This includes information received from a source under the terms of the SSA Information Exchange Agreement. Examples of SSA-provided information could include response for verification of personal information or records containing SSA RSDI benefit information. SSA-provided data or information verified by SSA is sensitive and must be protected to prevent unauthorized disclosure. Workers must protect and ensure basic client confidentiality at all times. It is the responsibility of all workers to treat client information as they would like their own information protected if they were a client. This includes 1. Protect all clients, applicants, and recipients against identification, exploitation, or embarrassment that could result from the release of information identifying them as having applied for or having received public assistance. 2. Share information about clients only with those staff members involved with the case, unless client permission to release information to others has been obtained. 3. Access only client or staff personal or confidential information that is necessary for the performance of your job. 4. Remove no records or documents containing PII from agency offices, with the sole exception of authorized documents with a valid business need, such as documents being transferred to law enforcement agencies, county council, or the Superior Court. In these situations, Policies regarding transportation of information shall be followed at all times. 5. Make copies of documents with PII for official use only. Under no circumstances may unofficial copies be made. And 6. Immediately report any breach of security, unauthorized use of data, or the compromise of any confidential information to your supervisor or manager, verbally, in person or over the telephone, and via email. The supervisor or manager will immediately report the breach to the HSD Information Security Officer. It is each worker's responsibility to ensure that access to client information is restricted to those with a legitimate business need. A legitimate business need means that you are required to look at the information as part of your position or work relationship with HSD. Under no circumstances are workers to look up or change any type of information about their own case or the cases of potential conflicts. Please consult with your supervisor about the appropriate channels to request information about your own case or any case that could be a conflict of interest, such as family, friends, neighbors, co-workers, acquaintances, etc. If someone does not have a legitimate business need to view client information, they must not view that information. Entering into an electronic or a hard case file with no legitimate business need is considered a breach of confidentiality. Failure to protect client PII and client confidentiality, or to use client PII in ways other than in direct performance of job duties, may cause workers to be subject to disciplinary actions, including termination of employment and/or civil and criminal sanctions through both federal and state statutes. Workers in the Human Services Department, along with contractors, volunteers, and others, constantly come into contact with client information. Much of this information is PII. It is important for the workforce to safeguard this information and for clients to trust that this information is used in a proper manner. Compliance with various state and federal regulations and security agreements is also a top priority to HSD. These agreements include the Computer Matching and Privacy Protection Agreement between the Social Security Administration and the Health and Human Services Agency of California, the California Department of Healthcare Services Medi-Cal Privacy and Security Agreement, also known as MedSecurity, the CDSS Social Services Privacy and Security Agreement, or the PSA, the Technical System Security Requirements established by the Social Security Administration and Homeland Security, and especially the Privacy Act of 1974. One of the most important agreements is the Privacy Act of 1974. The Privacy Act created a code of fair information practices that govern the collection, maintenance, use, and dissemination of information about individuals. Federal agencies or their contractors, such as counties and their agents, must maintain a system of records, and it prohibits the disclosure of a record about an individual without their written consent. The Act ensures individuals have the right to determine if their records have been disclosed and to make corrections to their information. HSD has incorporated processes to assure that client privacy and confidentiality remains a top priority. Reviewing the confidentiality statement is part of the hiring process. It requires each new worker to sign a non-disclosure confidentiality agreement as a condition of employment within HSD. This signed document is maintained within each worker's permanent file for a minimum of 5 years. Upon annual performance review or annual contract renewal, each worker completes a refresher training course and signs a new confidentiality statement. This new document is routed and maintained within each worker's permanent personnel file for 5 years as well. All agents, including subcontractors, consultants, vendors, and volunteers, agree to the same confidentiality requirements as other workers and HSD employees by incorporating appropriate language to all contracts, independent contractor agreements, and memorandums of understanding, also known as MOUs. All workers follow the County of Santa Cruz policies for computer and network usage and information security. The next segment of this course will address what is known as conflict of interest. HSD maintains the policy that all workers must be free from conflicts of interest that could adversely influence their judgment or objectivity in conducting department business activities and assignments. It is important to understand that this policy also includes giving the appearance of conflict of interest. The department does recognize that workers may take part in legitimate financial, business, charitable, and other activities outside their jobs. However, any potential conflict of interest raised by those activities must be disclosed promptly to their manager. Workers must avoid relationships or commitments which conflict or appear to conflict with the interests of clients, and should avoid relationships which would compromise or appear to compromise their integrity or judgment. Workers who are in relationships with HSD clients should take steps to ensure that they do not function in a decision-making capacity in terms of the services provided by the department to those clients. Workers in these relationships are also covered under the privacy and confidentiality policy, prohibiting them from reviewing case information. Workers must resist influences or pressures which could interfere with professional discretion and impartial judgment required for the performance of job duties. No worker may, under any circumstances, exploit their position with HSD for personal gain. No worker may accept, either directly or indirectly, gratuities, gifts, or favors of any kind from clients, contractors, potential contractors, or other persons where such an action could be construed as an attempt to influence department actions or policy. This also includes workers looking at their own case files. Under no circumstances are workers to look up or change any type of information about their own case or cases of potential conflicts. Please consult with your supervisor about the appropriate channels to request information about your own case or any situations defined in the Information Security Confidentiality Statement. When a worker cannot politely refuse a small gift of thanks from a client, it is appropriate to donate the gift to a nonprofit agency rather than keep or consume it. It is the responsibility of each worker to inform their immediate supervisor whenever they have or have had a personal or business relationship with a client or applicant of the agency that could create or create the appearance of a conflict of interest for them. Examples of possible conflicts that would need to be reported would include, but not be limited to, information about family members, friends, neighbors, or past or current co-workers. One area with potential conflict of interest involves HSD's Family and Children's Services, also called FCS, along with County Council, as they make decisions which involve child welfare placement issues. For instance, HSD's Family and Children's Services is responsible for making relative and non-relative foster and adoptive placement recommendations regarding children in the child welfare system to juvenile courts. County counsel, in turn, represents the FCS division in juvenile court and acts as its sole counsel in all juvenile dependency court proceedings regarding children placed by the department in relative, foster, or adoptive homes. Consequently, employees of FCS and county counsel must not be considered for non-relative, foster, or adoptive placements of dependent minors in Santa Cruz County. An application for foster care licensing from these employees constitutes a conflict of interest, and any such inquiries or applications received by FCS must be referred to the State Department of Social Services Community Care Licensing Division and or a private foster family agency. If subsequently licensed, these workers would be eligible to receive placements from neighboring county child welfare agencies. Non-employee workers must disclose to FCS their intention of consideration for foster adoptive parent. FCS will make the determination whether Santa Cruz County is the most appropriate licensing source. Requests by any FCS and county council workers for relative placement of dependent minors in Santa Cruz County must be evaluated by the FCS division director on a case-by-case basis. These placement decisions must consider the needs of the child and his or her relationships with extended family members, as well as the rights of parents receiving reunification services. All cases must be carefully evaluated to address actual or perceived conflict of interest, and some situations may warrant transfer of jurisdiction or independent review by another county social services agency. Workers engaged in research should consider carefully its possible consequences for clients and should ascertain that all participating clients have given informed and voluntary consent without any implied deprivation or penalty for refusal to participate, and with due regard for the participants' privacy and dignity. Now let's review some important policies, starting with the acceptable use policy. The purpose of this policy is to protect the integrity of the data that resides within the county's computer systems, prevent data from being stored insecurely or accessed by unauthorized individuals, and to protect the county's information technology resources from misuse or misappropriation. As a worker, you are required to follow computer protocols by protecting your passwords and never sharing your login information. All workers are required to adhere to the email use and retention policies, since all email communications are subject to the Public Records Act. Employees must encrypt any email containing PII sent outside the county network. Workers must maintain cybersecurity by being cautious of 1. Farming. Farming is a malicious website that resembles a legitimate website used to gather usernames and passwords. Think before you click. 2. Phishing. Phishing is an email sent from an internet criminal disguised as an email from a legitimate, trustworthy source. The message is meant to lure you into revealing sensitive or confidential information. Remember, personnel will never send an email requesting your Social Security number. Don't respond. 3. Spear phishing. Spear phishing is more targeted to the individual. Attackers scour the internet looking for information about certain individuals. They use that information to create a personalized email sent directly to one individual. The email is crafted to look like it is coming from someone you know and trust. Typically, the email will contain a link to a program or a website that will attack the victim's computer or steal private information. And 4, spoofing. Spoofing is a type of scam where a criminal impersonates another individual or organization with the intent to gather personal or business information. You must resist the temptation to click on an unknown link. Let's now review the breach reporting policy. It is the policy of the Human Services Department to report possible compromises of personally identifiable information, PII, or information security breaches of any type as quickly as possible and in full compliance with all state and federal regulations. It shall be the responsibility of all workers to immediately report any possible compromise of PII and all security incidents to their supervisor with both a phone call and a written email. The supervisor will immediately notify the county information security officer. The next policy that we will review is the encryption policy. This policy pertains to email, laptop or desktop computers and mobile computing devices, removable media, data transmissions over networks outside of county control, electronic files, and voice recording devices. No worker shall send any email or transmission containing any personally identifiable information, PII, outside the county network unless the information is encrypted. This encryption tool must be a solution using a vendor product that is recognized as an industry leader in meeting the needs for the intended solution. No worker shall utilize any personally provided removable media on any HSD computer. No worker shall copy any PII onto any type of removable media, such as floppy disk, CD, or DVD, unless it is encrypted and only with prior authorizations. Workers may utilize a voice recording device in the performance of their job only if that device has been provided by the Human Services Department and that device is encrypted. The final policy that we will review is the transportation policy. The removal of any PII from the HSD premises is strictly prohibited, except for identified routine business purposes. When transporting any type of PII, in accordance with HSD policy, workers may not leave PII unattended at any time in vehicles or airplanes and may not check PII in baggage on commercial airplanes. Medi-Cal PII may be removed from the premises of the Human Services Department for identified routine business purposes or with the express written permission of the State of California Department of Healthcare Services. When sending or transporting large volumes of Medi-Cal PII, it is required to use only a secure bonded courier utilizing a receipt system. As discussed, workers are to use client personal information only to perform job functions and must avoid a conflict of interest and protect client PII and client confidentiality at all times. Failure to protect or to use client PII in ways other than in direct performance of job duties may cause workers to be subject to both civil and criminal prosecution through both state and federal statutes, and may cause workers to also be subject to disciplinary action, including termination of employment. Frontline supervisors are responsible for ensuring that no worker has access to any client PII prior to signing an information security confidentiality statement. These standards are not intended to supplant or limit any other policies. Let's review the main learning points. Client privacy and client confidentiality is a top priority within the Santa Cruz County Human Services Department. It is understood that HSD staff are oftentimes in close proximity of or privy to individuals or families' personal information and case details of which are not part of their workload. It is the responsibility of the worker to understand the county's policies regarding these types of information and exercise sound judgment so as not to place themselves into a questionable position. We must comply with state and federal regulations. These policies apply to all workers, including temporary or extra help workers, contractors, consultants, volunteers, and other workers at the County of Santa Cruz facilities, including those workers affiliated with other departments and third parties who work with the public and who have access to PII. When the information is regulated by multiple entities, whichever is most stringent applies. We want workers to be aware that improper use of personally identifiable information may lead to discipline, including termination of employment. Know the proper process for notifying management if you think you may be conducting business which could be misconstrued as a conflict of interest. Civil and criminal sanctions and penalties are applicable. Certification. The County of Santa Cruz Human Services Department must comply with various state and federal agreements and laws concerning information security. Prior to accessing personally identifiable information and annually thereafter, each worker must certify that they understand and agree to maintain client confidentiality and privacy and agree to protect personally identifiable information in their work performance. Let's review the Confidentiality Statement Agreement. Confidentiality Statement Agreement. Let's begin with definitions. Personally identifiable information, or PII, is any information that can be used alone or in conjunction with any other information to identify an individual. PII includes any information that can be used to search for or identify individuals or can be used to access their files. Examples of PII may include name, social security number, social security benefit data, date of birth, biometric records, official state or government issued driver's license or identification number, and or case number. Worker. Any employees, temporary or extra help employees, contractors, subcontractors, consultants, vendors, volunteers, and agents of the County of Santa Cruz HSD, including workers affiliated with other county departments and third parties who access HSD computer networks. Let's review the agreements. As a condition of employment within HSD, all workers performing any functions for the county that require access to restricted areas, systems, and or use of PII are required to 1. Protect all clients, applicants, and recipients against identification, exploitation, or embarrassment that could result from the disclosure or release of information identifying them as having applied for or having received public assistance or services. 2. Keep confidential all information and records obtained in the course of providing services to clients, applicants, or recipients. 3. Share information about clients only with those workers involved with the case, unless client permission to release information to others has been obtained. 4. Immediately report to manager or supervisor any interests or relationships that may pose actual or perceived conflicts of interest with family, clients, employees, or business associates. 5. Access minimum necessary personal or confidential information for which there is a business need. Workers are not to look up or change any information about their own case or the cases of potential conflicts. 6. Keep all records and documents containing PII in the office unless there's a specific business need to transport the information. And then follow county procedures for encryption of electronic records and transportation of hard copy records. Under no circumstances whatsoever shall records or documents containing PII be taken home, left unattended in a vehicle, or checked on an airplane. 7. Create copies of agency records or documents containing PII for official use only. By no means may any unofficial copies be made. 8. Protect the security and integrity of the systems and the data within the county network, adhering to acceptable use, data management, email use, and malware prevention policies. 9. Report any breach of security, unauthorized use of data, or the compromise of any confidential information to manager or supervisor as soon as possible. Let's review penalties. Violation of any of the agreements listed may subject the worker to disciplinary action, up to and including dismissal from employment or termination of contract. Wrongful access, use, modification, or disclosure may also subject the worker to civil liabilities for damages, as well as criminal prosecution pursuant to state and federal laws. By signing the confidentiality statement, you acknowledge that you understand your role and responsibilities as an authorized worker for the County of Santa Cruz Human Services Department. You understand the consequences for violation of any agreements listed and agree to comply with these policies and requirements. Thank you for participating in this important training. And remember, you play a vital role in maintaining client confidentiality and privacy, as well as protecting personally identifiable information, PII, within HSD.